Your Honor, at this time, the state has no further witnesses. The state will rest.
All right, the state has rested its case, which means the state's portion of the evidence is done. I'm going to excuse the jury for a few minutes before you go home for the evening. Let me just do a consultation with the parties about tomorrow's schedule, and I'll let you know what time to report back. It should just be a couple minutes. So please remember the admonition. We'll let you know what time to report back tomorrow. State's rested, so do you plan on presenting evidence?
Can I confer with my
Yeah, go
team
ahead.
for a minute? Your Honor, I'd like to address a Rule 20 motion first.
Go ahead.
Okay. The state has failed to show substantial evidence for count 1, conspiracy to commit first-degree premeditated murder. The state has provided no evidence that I agreed with another person that any one of us would engage in certain conduct that I intended to promote or assist in this premeditated murder. Crime premeditated murder requires the state to establish a person caused the death of another with premeditation. The lack of evidence to show any evidence of a conspiracy to commit murder, there was no plan to murder Charles. No evidence has showed that, in fact, evidence suggested self-defense on the part of Alex. So I would like to put that on the record.
All right. State want to put a response on the record?
Yes, Your Honor. Looking at the evidence in the light most favorable to the state, there's sufficient evidence based upon everything from the iCloud messages from between Alex, the defendant, and others leading up to July 11th of 2019, that Alex Cox was invited over by this defendant, knowing that they were going to be having an intervention and knowing when Charles would be there and bringing a handgun over with him. The timelines on July 11th of the killing of Charles Vallow and the fact that the number of shots and the physical evidence at the scene, the statements by the defendant to Detective N-Clan that she took Charles Vallow's phone and would not give it back to him, the motive for money, and especially the defendant's motive for having an affair with Chad Daybell, all of those looking at together in the light most favorable to the state the defendant, or the jury could find the defendant guilty of conspiracy to commit first-degree murder.
Last word. Do you want to add anything?
No, Your Honor.
All right, the standard is whether or not a reasonable juror could, whether or not there's substantial evidence for a reasonable juror to find the defendant guilty. The court does find that there is substantial evidence that a reasonable juror could find the defendant guilty. The court will further add that the jurors are the ones who judge the credibility of the witnesses, and it's ordered denying the Rule 20 motion. Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
No, Your Honor, the defense will rest.
All right, if that's the case, I'm going to tell the jury. How long does the state anticipate its closing argument being?
I would assume probably over an hour.
How about the defense?
Less than that.
Can we do the closings at 1 p.m.? We can formalize all the jury instructions at 10:30.
Your Honor,
Is that enough time?
the state would request that we do them Monday to ensure that the state would request we do closings Monday to ensure that we don't finish with a rebuttal closing on Monday.
Well, I'm willing to go in the morning if we want to start in the morning at 11 and do jury instructions at 10:15 or something like that. Does that work?
Again, I'm asking for Monday, but if the court does not allow that, then we'll go whenever the court says tomorrow.